going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. All right. You guys remember that sovereign citizen from this morning? Like 2 hours ago? Well, he was in court, the same court, Judge Shackelford, on a completely separate hearing. He had two cases on the same day with two different credit card companies. This one might even be better. Only because what Judge Shackelford says to him at the end of the video. I don't think he says more than 3 words during this entire hearing, but it's the end that's hilarious. We got to go through all the court stuff, all the boring stuff before we get the great stuff. So stick with me. It will be worth it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
All right. And I've got Mr. Chavez back. Do I have Discover Bank still?
Yes, Your Honor.
All right, Mr. Chavez, can you turn on your camera and your microphone, please, sir? All right, we're back on 24010674. The Discover Bank versus Arnold Chavez. Can I get appearances?
Good morning, Your Honor. Michael Goethals, P number 48992 of counsel to the law firm of Buckles and Buckles, appearing on behalf of Discover Bank.
All right, Mr. Chavez, tell me your name.
Chavez Arnold.
All right, and I know that we had a previous court date on this on October 10th, and the default was filed, and then an objection was filed timely on this case. So we're here to set aside the judgment. What's your motion, Mr. Chavez?
Well, that day, Xfinity, I have Xfinity internet, and it was working in my area. And I have proof of, I talked to them in the chat. They confirmed it. And I have they gave me a bill credit for the inconvenience. So that's why I wasn't able to attend, because I was having problems with my internet.
All right, and just so you know, Mr. Goethals, we did have notice that he had contacted the court and that he was unable to get on that day.
Oh, he contacted the court on October 10th?
I'm not sure if it was on October 10th, but it was shortly thereafter. If it wasn't October 10th, that he was having internet issues and could not get on. So here's what we're doing. I'm assuming, Mr. Chavez, do you have a defense on this case?
I just want to go through the due process.
Okay. All right. Here's what we're going to do. I'm setting a date. So what do we need discovery on this? Mr. Goethals, so this is a credit card bill?
Yes, Your Honor, a Discover card.
All right, and this is Discover Bank, so there's no issue as to whether or not it's transferred hands?
No, Your Honor, we represent the original creditor.
All right, and I see there's an answer file. All right, this is an account stated.
Yes, Your Honor. I believe there's also a contract count, breach of contract count.
All right. Under MCR 2.116, parent I, this court is making a ruling immediately based on the pleadings. The answer from Mr. Arnold indicates that he does not dispute that the card was taken out. The only dispute he appears to have is that a few paragraphs here, he does not agree with the fact that by virtue of defendant's default and breach, the entire balance of the account is now due, and these statements were attached, that the contract and or monthly statements are written instruments, evidence indebtedness with a specified interest rate, and that he disputes whether or not it's an account stated. It clearly is. It's the original creditor. There's no sort of defense regarding assignment on this case. The balance at the time of the complaint was $4,378.29. Under MCR 2.116, parent I, parent 1, if the pleadings show that a party is entitled to judgment as a matter of law, or if the affidavits or other proofs show that there is no genuine issue of material fact, the court shall render judgment without delay, and the court is doing so.
Well, I have affidavits that support what I'm saying, but I will want to enter into this as evidence.
The motion for summary disposition is granted sua sponte by this court. There is no valid defense claim, and
I couldn't even enter any evidence.
And a judgment in the amount of what is claimed in the complaint, $4,378.29 will be entered by this.
All right. Judge Shackelford is completely ignoring him, not even letting him give a defense or anything. I mean, he filed a response, so that's his defense. But how about the fact that this guy has multiple debts with multiple credit card companies and doing the exact same thing? She's over it. I mean, his first case happened 2 or 3 hours ago. I already put a video out. I will put a link in the description if you guys haven't seen the video from this morning. It's good. He says a little bit more during that one. She shuts him down. And this is when she's about to flip out on him, which is great. I told you guys if you waited till the end, it would be worth it. All right, I'm going to let it play out. You guys have a great rest of your day. Hope you enjoyed it. Hit the like button if you did. Until next time, bye.
Court and documents can be submitted for that purpose. And officer, I have a few more documents for that. And we're all set.
Thank you, Your Honor. Are we to submit a judgment under the 7-day rule?
Yes, sir.
Okay,
No.
and
Just submit it to the court. It's an order of the court. I've sua sponte granted a motion for summary disposition.
Okay.
You can submit.
Is that something we can file by email then?
You can file it at civil at court23 taylormi.gov.
And that'll be in the complaint amount plus our filing and service fees, correct?
Correct.
Thank you, Your Honor. We will do that.
All right, we're all set.
I
Thank you,
don't have
Mr.
no
Arnold.
words.
Mr. Arnold, I have ruled against you.
I
I
have
am allowed
evidence.
to do so on the court rules. You filed an answer. It's the appropriate response to this. You're not going to make a mockery of the judicial system, which is what you're attempting to do. You're also not going to waste this court's time and resources on cases, on arguments that are invalid. I'm not wasting any more time on it. We are done. Thank you.
Thank you, Your Honor.
Colin.